Hi, I'm Ellie Williams, the Legal Director of the Justice for Incarcerated Survivors program at the Georgia Coalition Against Domestic Violence. Thanks so much for joining us and tuning into Until They're Free, a podcast series brought to you by the Georgia Survivor Justice Initiative. Ultimately, it feels like being killed by my abuser would have been easier than living through this. Everyone told me they thought it was me who would end up dead. Walk a mile in my shoes. Wouldn't your feet feel pain too? After years of turning a blind eye, people are finally starting to open their eyes and ears to the voices of domestic violence victims. We are here. We are real. We have something to say. Listen to our voices. These words of survivors in our community should make us all stop and think. Is the legal system really working? Are we really protecting victims of violence? Or are we really doing more harm? We hope to bring you, our listeners, information about the criminalization of survivors through different lenses. The perspectives of survivors, their loved ones, attorneys, storytellers, legal scholars, community members, and more. We hope to elevate survivors' voices, uplift this critical issue, and mobilize our community to advocate for impactful, meaningful change that will ultimately end the criminalization of survival. We are here. We are doing the work, and we will not stop until they're free. We are so lucky to kick off this series with our first guest, Professor Leigh Goodmark. Professor Goodmark is the Associate Dean for Research and Faculty Development at the University of Maryland Francis King Carey School of Law. Professor Goodmark is one of the nation's leading experts and legal scholars on the criminalization of survivors. Through her many years of experience working with survivors in a variety of settings, conducting research, publishing books and articles, and directing a law school clinic, Professor Goodmark has incredible expertise on how the legal system impacts survivors of domestic violence. We got to chat with Professor Goodmark and ask her a number of important questions, and we are really excited to share that conversation with you. Thank you so much, Professor Goodmark, for joining me today, and we're excited to chat with you more about your work and the criminalization of survivors and the Survivor Justice Initiative that we are working on. So thanks for being here today.
Thanks so much for having me.
Professor Goodmark, do you want to introduce yourself? Tell us a little bit about your background and your work generally and your work with criminalized survivors.
Sure. I'm Leigh Goodmark. I am the director of the Gender, Prison, and Trauma Clinic at the University of Maryland Francis King Carey School of Law. I have been working with victims of violence for about 30 years. When I first came out of law school, I started working with survivors in family law cases, particularly protective orders, but also custody, divorce, child support, kind of you name it. And I did that work as a legal services lawyer. I then did some national level policy work around children and domestic violence, particularly around the overlap between child maltreatment and intimate partner violence. And then I became a clinical professor in 2003. And for the first 20 years, no, that can't be right. For the first 10 years that I was a clinical professor, we mostly did family law. 10, 11 years ago, I came to the University of Maryland and I started a clinic here. That was more a general practice clinic that defined its work not by the kinds of cases that we did, but by the kinds of people that we served. So it was a clinic that served anybody where gender and violence were touching each other in any way. And that included family law, but also immigration and civil rights work and property work and all kinds of things. And in the first year that I was here, I picked up a parole case. I had never really done that work before, although I had been interested in thinking about women who fought back against their abusers, had written some about that before I started this clinic. But when I started working with our first parole client, thought, oh yeah, this is the work that I was supposed to be doing. And since that time, the clinic has slowly but surely become a clinic focused on providing post-sentencing representation to survivors of various forms of gender-based violence. And since we consider prison to be a form of gender-based violence, we'll pretty much serve anybody who is serving And so we do commutation, we do parole, we do post-sentence modification work, we do presidential pardons occasionally, and we do policy work around these issues.
Wonderful. Thank you so much. And we know you've done so much amazing work. And you bring up something I think that's really interesting in terms of structure of legal services pertaining to gender-based violence and really legal aid generally around the country. It sounds like your clinic had a pretty unique model and not necessarily being narrowed to a particular area of law, but kind of providing a number of services. Would you be able to talk about a little bit? I think in generally folks receiving services from legal aid organizations, survivors of gender-based violence, a number of different people. Most people tend to have not one isolated singular issue, but a lot of different things going on that are contributing to their situation, which is really, we understand the criminalization of survivors to implicate the intersection of a lot of different issues in our legal system and in our society more broadly. So would you be able to talk a little bit about that and kind of what you've seen through your work about people's experiences?
Sure. So as you've said, Ellie, most people who walk through the door, maybe they come in with one primary issue. And maybe for us, often that primary issue is this violence needs to stop yesterday. And so we think about the tools that we have at our disposal to help that violence stop as soon as we can do that. And, there are conversations to be had about the effectiveness of the legal system in doing that. But take as granted that we try to use the tools that we have to best help the people who come to us for help. So you do a protective order case, but then somebody's got long-term housing issues and they've got child custody issues and they've got child support issues. They may want to get a divorce. They may have immigration issues. They may have other kinds of issues as well. And oftentimes our legal services are siloed. One set of people does protective orders, but they don't do any of those other things. I wanted to think about how we could do all of those things. And granted that a law school clinic is a fairly low volume organization, but it's a nice way to think about how we might better provide services to survivors. That if we organize ourselves around what they need as opposed to this category of things that we are equipped to provide, we might do a better job at meeting a multiplicity of needs. And there are absolutely survivor organizations that are doing that work that way.
Yeah, wonderful. Thank you. And I think you bring up a really important point about meeting survivors where they are and acknowledging their experience and making sure we're doing an effective job as service providers, but also looking at the legal system, systems on the whole, the law. And, we tend to think the legal system has issues with things being structured to adequately account for survivor experience, which we see manifesting in this problem of the criminalization of survivors. And I know in your scholarship and the books that you've written, you've talked a lot about kind of your evolved perspective and the evolution of the criminalization of survivors and how that kind of fits into the interplay between the law and our sociocultural and really scientific understanding of abuse and its dynamics. So would you mind talking a little bit about that from your experience and kind of more generally?
When I came out of law school, it was 1994. That was the year that the Violence Against Women Act passed. And when I started doing this work, I was a carceral feminist. Carceral feminism is used now as an epithet, but I mean it as explanatory. A carceral feminist is somebody who believes in using the punishment power of the state to end gender-based violence, among other things. And that was me. At that time, when I came out, we thought, the only way to deal with this problem is by involving the criminal legal system, that these guys, and at the time we were only talking about guys, usually in heterosexual and marital relationships, needed to be locked up, that they couldn't change, and that was the only way that we were going to keep people safe. And I very quickly was disabused of that notion by my clients who said, we are not interested in having our partners locked up. That will create hardship for us. That will make it more difficult for us to parent. That will jeopardize our housing or our economic situation. That will cause ostracism from our communities. I love this person, and I don't want to see this happen to them. And so I very quickly started to question our reliance on the criminal legal system. And that questioning, snowballed when I saw how badly the criminal legal system actually responded to people. That it's not a particularly survivor-friendly system, that survivors lose a great deal of autonomy and agency in dealing with that system, that it doesn't provide people with the things that they actually want and need. And then when I became an academic, I started to do the research and learned that in addition to the fact that my clients were saying it wasn't giving them what they needed, in fact, what the research shows is that the criminal legal system exacerbates many of the things that correlate with the perpetration of violence, like economic distress and experiencing trauma and community dysfunction. And so I've spent the last, 30 years evolving. And I would say, again, 10, 11 years ago, when I started representing clients who are incarcerated and spending time in prison, that really brought me face to face with this question about, is prison a good answer to anything? And being in and out of the prison, and I should say, our prison as they go, not that bad, looks like a rundown community college, but it's not a place that I would want to be. And it is a place that absolutely inflicts trauma on my clients on a daily basis. When, as Brian Stevenson says, you get proximate to the problem, it's hard not to change your views. And certainly that's what caused me to change mine. The last step for me was not just kind of knowing that my clients didn't love this system and knowing that the research said it wasn't working, but also looking at what it looks like when people are caged. And for me, coming face to face with that was the last step for me to becoming an abolitionist. And so I started in one place. I've ended up in a very, very different place as a result of my experiences of representing survivors over the last 30 years.
That's a super helpful picture. Thank you. I think to your point, and kind of taking a step back, we understand the criminalization of survivors, which of course we'll continue to talk about as being one particular way that the criminal legal system harms survivors. And you bring up another kind of, broad and prevalent one, which is survivors saying, I don't necessarily want him to go to jail. I don't want to ruin his life. I don't want the financial hardship that would come with my partner being incarcerated. Would you talk a little bit about that particular phenomenon and then kind of some responsive alternatives to the criminal legal system and the carceral system that folks have started to develop and implement across the country in response to that challenge?
So many of our clients rely on their partners for things that are absolutely necessities. They rely on their partners for economic support. They rely on their partners for housing and transportation and community acceptance. They rely on their partners to co-parent with them. They rely on their partners for emotional support. And when we suggest that the way to solve the problem of intimate partner violence is to destroy those relationships through the use of separation, through arrest, through prosecution, through incarceration, through divorce, through protective orders, whatever that looks like, and that's the only option that we provide to people, what we are saying in effect to them is, we don't care about how you value these relationships. That doesn't matter to us. And in addition, we're actually not going to do anything to deal with all of the underlying issues, because maybe if you could provide me with housing, maybe I would want this relationship to end. I might still not want criminalization for my partner, but I might want to end this relationship. If you could ensure that I was going to have economic support, if my kids had everything that they needed, maybe I would want this to end. And there are some supports out there. There are some resources out there, but honestly, not anything that approximates what it is to have a partner in your life on a day-to-day basis. We tend to be very simplistic about intimate partner violence. We tend to assume that if there is violence in a relationship, then nothing about that relationship can possibly be good and nothing about it can possibly benefit the survivor in any way. That's simply not been my experience with my clients. It is much more nuanced and complicated than that. And that's again particularly true for people who love their partners and just want the violence to stop. And there are lots of folks like that. We do nothing for those folks when all we offer them is separation-based options. And so thinking about what we could do instead. Now, I have written this book called Decriminalizing Domestic Violence. It suggests that instead of looking at domestic violence as a criminal problem, we look at it as an economic problem, as a public health problem, as a community problem. And so some of the things that I talk about in that book are the research that shows us that economic distress and economic instability are driving violence. So how do we give people economic stability? Through guaranteed living wages, through raising the minimum wage, through ensuring that our loss of manufacturing jobs is not causing violence and helping people in communities where jobs have been lost to find work. It's not at all surprising that, for example, during the COVID pandemic, rates of COVID went up pretty sharply. And then they came down, and they came down at the same time that people got their stimulus checks. Because when you ease people's economic burden, violence goes down. We can do this work by doing prevention work, which we don't do well in this country. But the research tells us that adverse childhood experiences are highly correlated with the perpetration of violence. So why aren't we putting money into working with families to ensure that their kids are not witnessing violence, are not being neglected or mistreated? Put that money into communities to ensure that our kids are not seeing community violence. Community instability, again, a factor that leads to the perpetration of violence. How can we strengthen communities, deal with the variety of problems that communities are facing, right? All of these things are things that we can do instead of just locking people up. And then, as I said before, half of people never go to law enforcement in the first place. So how do we equip people in community to be able to respond to violence? And the transformative justice movement is doing amazing work around creating community accountability programming, thinking about the various things that people can do to be there for their neighbors, their friends, the people in their community to help prevent violence and to respond to violence in ways that don't involve punishment. And restorative justice is one of those things, but it's not the only thing. People have talked a lot about restorative justice in recent years. I love restorative justice if it's done right in the context of violence, which is a whole other conversation. But suffice it to say, right, that's one thing, but it's not everything.
Super helpful. And certainly good to hear, I think, the reasoning behind all of these things. Because I think to your point, sometimes we as a society have a really hard time unless we have personal experience with abuse or have a great quote, become proximate to the problem and discuss directly interacting with survivors and talking about their experience. I think the whole, but I still loved him and he was still my partner is something that people have a really hard time understanding. And it's something that makes why survivors might stay in abusive relationships or stay in closer contact with their abusive partner than we might think seems makes sense to us. It gives it more context and understanding when we um, really holistically understand that it's not quite as simple as harm equals we never have any positive experience with that person or we never have any feelings of love for them.
Years ago, the Vermont Integrated Domestic Violence Court did a study and asked the couples who were coming through the court how many of them thought that how many of them were still together and how many of them planned to stay together. And upwards of 90% of those couples said they were either still together or planned to stay together.
Wow.
So if we're
That
not thinking about what we do for folks who want to maintain those relationships, we are doing a huge disservice to the vast majority of people. I know that's
mm,
just one study, but I think it's a particularly telling one.
certainly, and 90% would be a large number for, obviously variation would leave us still to where a substantial number of folks are feeling the same way. And I think in talking about kind of general misunderstanding of abuse and its dynamics or lack of accounting for understanding that we do have in the system, we see kind of another iteration of the issue of the criminal legal system harming survivors playing out in our clients, your clients and my clients, those who are charged, prosecuted, convicted, sentenced of crimes that are directly related to the abuse in one way or another. So, would you mind talking a little bit about, I think, kind of just the criminalization of survivors generally? I think it's important in talking about it holistically, as I know you'll talk about. But that when we think about that problem generally in the community, we tend to kind of immediately jump to self-defense and
Mhm.
survivors protecting themselves against their abusive partner, which is certainly a substantial part of the reason survivors are criminalized, but is one piece of a larger puzzle with kind of different ways that survivors get or intertwined with, entangled in the criminal legal system. So, kind of helping to frame that issue and help us to see, kind of from a broader lens, how we could describe that problem and different ways that it manifests.
So in my book, Imperfect Victims, I say that survivors come to the criminal legal system in really three different ways. First, survivors come to the criminal legal system when they report themselves to be victims of crimes. So a survivor calls the police and says, I have been harmed in some way. And the police show up at the scene and say, well, he says you did it, there are defensive injuries on him, or you've mouthed off to me and I don't like the way that you're talking to me, or you say, I'm no longer interested in pursuing this. I just wanted you to come kind of stop the violence in the moment. And they say, well, if you're going to change your story, then you're committing perjury, or your unwillingness to talk is an obstruction of justice. And so when survivors make that initial call, sometimes they are mischaracterized as primary perpetrators, or they do other things that lead police and prosecutors to charge them with crimes themselves. People also come to the criminal legal system as witnesses. In many jurisdictions, prosecutors have policies that say that they are going to pursue cases of domestic violence, regardless of whether the complaining witness wants to go forward with that case or not. So you call the police. Again, I just want to stop the violence at the moment. This is the only game in town for doing that, as you know, as of now. And so my first responder comes, they make an arrest, and I say, well, I'm not interested in prosecuting. I have other things going on in my life. I just needed you to come sort this out. And the prosecutor says, I don't actually care what you want one way or the other. As a guardian of society, it's my job to ensure that the bad guys go away. And therefore, I'm going to prosecute this case and I'm going to subpoena you to testify. And if you choose not to comply with that subpoena, which compels you to come to court and testify, then I'm going to ask that you be arrested. And once you're arrested, I'm going to ask that you be held, maybe for a day, maybe for a week, maybe until this case comes to trial, to guarantee that I get your testimony. The vehicle that people use to do this is called a material witness warrant. In different places, it's called different things. In Maryland, where I practice, it's called a body attachment. And prosecutors are taught in dealing with domestic violence that a material witness warrant can be a way to get a reluctant witness to testify. But what that often means is that that person is jailed in the same jail as the person who harmed them for some undetermined amount of time with none of the rights that attach to criminal defendants. And so in a very famous case out of New Orleans, Renata Singleton was jailed for a week in the same jail where the guy who hurt her came through. He didn't stay because he bailed out, but she couldn't pay the bail. And so she was there for 5 days until she was brought into court, shackled to everyone else in an orange jumpsuit. And at that point, let out on an incredibly high bond and electronic monitoring. This is the victim in this case. And of course, her ex-boyfriend then pleads out. So they never needed her testimony in the first place. Cases like Renata Singleton's are the single thing that make me the angriest in a system that makes me angry about a lot of things. But the misuse of material witness warrants, the abuse of material witness warrants, I think is particularly egregious. And then, of course, people come to the criminal legal system as defendants. Sometimes, as you said, Ellie, because they have acted in self-defense and their self-defense claims have yet to be adjudicated or are not believed. Sometimes because they are self-medicating against abuse. And so they may be using drugs, they may be using other kinds of substances and committing crimes to support a habit. Sometimes because they have acted under the duress of an intimate partner or under the coercion of an intimate partner who says to them, if you don't do this thing, I will hurt you. Sometimes as accomplices, and I'm on kind of air quotes around the word accomplice because it's not like people really are choosing to do things. Sometimes because they are at the scene of a crime when their abusive partner commits a murder, and that makes them part of a felony murder, depending upon whether they have been involved in a robbery or some underlying crime that exposes them to liability for what's called felony murder. Felony murder is just if someone is killed while a felony is being committed, then you can be held responsible for that killing, even if you are not the one who has done any of the killing, anything wrong. So you could be the getaway driver, but if somebody is killed, you're responsible. We have a client who was ordered by her abusive boyfriend to tie up two people, and then she fled the scene. And as she fled the scene, she heard gunshots. But because she had been there at the point at which they were being tied up, she was liable for felony murder, and she served 42 years in prison as a result. So all of these different ways are ways beyond just kind of the classic self-defense. I'm going to date myself, but kind of Farrah Fawcett in the burning bed. Nobody who listens to the podcast is going to have any idea who that is. But beyond that kind of classic scenario of in the moment, in the heat of things, I acted in self-defense.
Super helpful. Thank you. And I think your framing of victim versus witness versus defendant is really helpful, that there are a lot of entry points where victims really end up with charges. And I think you bring up one that I find really important and really prevalent as well in kind of the survivor acting under duress or coercion by their abusive partner, which seems to kind of also go hand in hand a lot of the time with kind of the accomplice liability and felony
Mhm.
murder issues that you brought up. In your cases, we know that in several states, Georgia being one of them, as it stands, the law requires essentially that the coercion or duress involves some sort of really explicit threat by the abusive partner that happens right in the moment when the offense is happening. Tell us about kind of, your take on laws that are structured that way and whether they do or don't effectively account for survivors' experiences, the dynamics of abuse, and kind of how you see that play out in your practice or what's happening with your clients or just what you understand about the issue.
Yeah, I think there are two things about duress that make it really, really hard for people to use it effectively as a defense. One is this idea that there has to be some kind of super explicit threat. If you do not do X, I will kill you. What that ignores is what we've fought about or fought for in the anti-violence movement for years is an understanding of the context of a violent relationship. And so you may not need to have that explicit threat to know that that is what is coming your way should you not comply with what it is an abusive partner is telling you to do. It may not take the words, I will kill you, to know that in fact, this person will kill you if you choose not to help them. And so it ignores kind of the years of work that we've done as an anti-violence movement to be able to bring that context in self-defense cases. When you say in a duress case, you have to have that explicit of a threat. And it's important to realize, all the work that we've done around what used to be called battered woman syndrome and is now usually called battering and its effects and bringing in expert testimony, that's really it, depending on your state, that can be limited to self-defense cases. And so you can't bring that in a duress case in some places. You can't bring that in an accomplice liability case in some cases. So it creates real challenges to being able to provide that context for a finder of fact, whether that's a judge or a jury. The other piece of duress that's really hard is duress is not a defense to homicide. So if what you are being told is you kill them or I'll kill you, or you do something that will kill them and I'll kill you, you don't get to claim duress in many places. You have to, what one prosecutor said was, you have to take your chances because you don't get to trade your life off for somebody else's. And so even though there's an external force that's causing you to do this thing, it's not as though you're doing it of your own volition. If it's homicide, you basically have to be killed rather than taking someone else's life.
And to your point, I think on, the excluding homicide, it becomes really hard if you live in a state like Georgia is with the broad felony murder rule. Because to your point, if you were under duress or coercion, however you might define that generally, or as the law defines it, but for our clients, they were acting under the direction of their abusive partner to, for example, drive the car. And then in your client's example, she wasn't there for the actual, trigger moment or the moment in which the person died. She didn't participate in that part, but she was a part of that whole transaction or occurrence. So she's looped into the felony murder rule. And in Georgia, murder and felony murder is all charged in the same way. Essentially, it looks different on the indictment, but you have first degree murder in the same
Same in
sentence.
Maryland, first degree
And
murder. Yep.
yep, so you can't use duress, which puts survivors in a really difficult situation and harshly punishes them for a fairly minimal level of involvement in the larger situation and involvement that was, of course, not undertaken voluntarily.
Right.
So you brought up another, I think, really important piece in there that is definitely relevant in Georgia in talking about battered person syndrome. So As things stand in Georgia, and I know we're not the only state with this kind of challenge, we still tend to rely on battered person syndrome. And exactly as you described in our state, it becomes limiting because we can only use that in the self-defense context. But we also know that battered person syndrome is an outdated term because of our evolved understanding of abuse. So would you mind talking a little bit about kind of the shift that we across the country that folks who are really doing a good job of accounting for our evolved understanding of domestic violence, the kind of shift we've made from battered person or battered woman syndrome to the effects of abuse, the effects of trauma, the effects of battering.
Absolutely. In 1979, Lenore Walker, who's a psychologist, writes this book called The Battered Woman. And in that book, she describes something called the cycle of violence. And if you've ever taken a DV 101 training, you have learned about the cycle of violence, right? The tension building phase, leading to the acute battering phase, leading to the honeymoon period. And we can go into that more, but we really don't need to, because what I can tell you is that that was based on Dr. Walker's research, but there are critics who say that even Dr. Walker's research doesn't support the existence of the cycle of violence. So that's pretty controversial at this point. 5 years later, Dr. Walker writes a second book called The Battered Woman Syndrome. And in that book, she says that we can explain why it is that abused women, and again, very gendered at that time, kill their partners by looking at a combination of the cycle of violence and something called learned helplessness. Learned helplessness was a theory that was first developed around dogs who were beaten. And the Martin Seligman, a psychologist, said, if you beat dogs long enough, they will not leave their cages, even though they're free to go. And there's something about the experience of being abused that makes them unable to take agency and to leave. So Dr. Walker took the cycle of violence and said, people are going through the cycle of violence and it's getting worse and worse over time, and the cycle gets shorter and the violence gets worse. And at the same time, they're learning that they are not free to leave. And those two things come together in a moment where somebody perceives themselves as in immediate danger and they essentially snap and they kill their partner. And that explains why people kill their partners, right? Kill their abusive partners. It's the first time anyone has theorized in a meaningful way why battered women kill their partners, and it takes off. And states, all over the country start to pass laws saying, okay, you have to consider battered woman syndrome when you have a self-defense case, because otherwise you won't understand why this person did what they did. But the theory is pretty limited, because if you don't have evidence of the cycle of violence or somebody is acting in ways that are inconsistent with learned helplessness, you can't make the case, in addition to the fact that, again, not supported really by the evidence. And it's gendered in ways that people found really problematic. So the first iteration away from that was to say battered spouse syndrome, that it's not just women that this happens to, but it could be anybody. But that really isn't the biggest change. People started to see how limiting it was to be stuck with those two theories to explain why people did what they did. What they wanted to explain was, what are the effects of being subjected to domestic violence, and why would that entrap someone in a relationship? So you see, new theorists coming in. Susan Schechter coined a term, coercive control, that was meant to describe the many ways that people subjected to abuse have their liberty and their autonomy limited by their partners. And then Dr. Evan Stark took that term, coercive control, and really popularized it. And so we weren't talking about battered woman syndrome anymore. We were talking about something much bigger, where there was an entire suite of behaviors that were being used to limit someone's liberty and autonomy. Battering and its effects allows you to get at that whole suite of behaviors and explain why it is that somebody feels entrapped in a relationship. Taking, for example, the work that the Duluth Abuse Intervention Project did around the power and control wheel, and thinking about all the spokes in the power and control wheel and how they're all contributing to somebody being coercively controlled. And so fairly early on in the 90s, you start to see people talking about battering and its effects. You get a pretty big federal government paper that says, really, we shouldn't be talking about battered woman syndrome anymore. We should be talking about battering and its effects. And most experts are going to use that terminology or that way of talking about the experience of being abused, rather than using the cycle of violence and learned helplessness. But the law hasn't kept up. And so you still see battered woman syndrome, or most often battered spouse syndrome, in state law, and in some places specifically defined as the cycle of violence and learned helplessness. And that's incredibly limiting because the field has so far progressed beyond those ideas. When you can talk about battering and its effects, then you can bring in the entire context of a relationship in ways that you can't when you're just talking about this cycle of violence and this very narrow conception of what constitutes intimate partner violence.
That is super helpful. Thank you. And definitely, in the work that we're doing in Georgia, we're really hoping to kind of point out to exactly the way you just explained that our understanding has evolved so greatly, but we still rely on these now outdated and have been, updated through modern scientific research. We rely on these old concepts that don't effectively account for survivors' experiences. So after the point at which someone unfortunately is convicted, because whether it's affirmative defenses or rules of evidence or all of these different ways, individual people in the system, the dynamics of abuse aren't effectively accounted for. After folks are convicted, we know that they are often sentenced pretty harshly, and that there seems to, in my experience at least, be a tie between abuse and high level severe felonies, really. And then also, it's really hard for people to challenge their sentence, and post conviction remedies, the kind of general ones that we all have really around the country, seem to be pretty stringent and hard to overcome, the standards in the law as they relate to post conviction remedies. So, what have you seen with relation to sentencing and post conviction relief for criminalized survivors?
In terms of sentencing, mandatory minimum sentences are a bit of a disaster for survivors, for criminalized survivors. If you take your chances on a self-defense defense and you're unsuccessful, or a duress defense and you're unsuccessful, you're looking at a pretty sharp mandatory minimum in most places. And for us, first degree murder is life. Second degree murder has a long mandatory minimum in a lot of places too. I'm thinking of Iowa used to be, I think, 50 years for second degree. And so a lot of times women will plead out rather than take the chance of hitting a sharp mandatory minimum. In addition, if you are not believed, so if your defense is about understand the context within which this happened. I was a criminalized survivor. Like this is why this happened. And a judge doesn't believe you, you tend to be sentenced. And I can't back this up with numbers, but my gut is you tend to be sentenced more harshly because you've made a victimization claim that you, in their eyes, haven't backed up. So the reason my book is called Imperfect Victims is because I argue that there's this very, very narrow stereotype of who a victim is. They're white, they're straight, they're middle class, they're cisgender, they're meek, they're weak, they're passive. And that's the person who judges and prosecutors and police are willing to protect. But if you're not one of those things, then you're going to get sentenced or judged more harshly. And by virtue of having been convicted, by definition, you're no longer a good victim. You're an imperfect victim. And so we tend to see pretty harsh sentences. And you see judges say things like, you're not a victim. You claim to be a victim, but you're not a victim. Nikki Adamondo in New York, I think, really publicly this came out with the judge saying, you had options. You're not a victim. And you see people say things like, you're too strong. You were angry, not afraid. You were jealous, not afraid. You made your own money, saying you were too sexual and therefore you're not a victim. And all of these things then get held against victims who don't hew pretty sharply to these stereotypes. So that's one layer of the problem. In terms of post-conviction remedies, in part because so many people plead and the remedies around plea bargains are so few, as long as the plea has been done constitutionally, you don't have much of a post-conviction remedy. And then in modification or in parole, you're always having to weigh how much of this context do I provide to this finder of fact or this decision maker versus I've already been adjudicated not to be a victim. So can I really raise this again? This comes up for us in parole cases all the time. And we have people who've argued, no, I was a victim, this is what was happening, they get convicted. And then at parole, if we try to tell the story of the context of the relationship within which the crime happened, oftentimes what the parole commission comes back to us to say is, well, then you're not remorseful. If you're still claiming to be a victim, then you're not telling the truth and you're not accepting your responsibility, and therefore you're not a good candidate for parole. Sentence modification is much the same thing. And so there's this very thin tightrope that we as advocates walk to say, we are not excusing this person's behavior. We are providing you with an explanation of how it happened. And sometimes that works and sometimes that doesn't. But having had your victimization claim rejected at trial because you've been convicted significantly narrows your options after that in sentence mitigation and in post-conviction remedies.
Super helpful. Thank you. And I think this whole kind of the last bits of our conversation have really painted a good picture of how the system tends to fail survivors at every juncture. And there are a lot of points in time that we could make changes to prevent either arrest, prevent conviction, prevent harsh sentencing, make it easier for folks who unfortunately have already been sentenced to be resentenced. But it becomes really it is really difficult as it stands. And I think something that you pointed out that is really important in thinking about sentencing laws in Georgia, particularly, we also have mandatory minimums. Our murder mandatory minimum is life with the possibility of parole. But when you have a survivor, when you look at it, kind of zoom out and compare, you have a survivor who unfortunately doesn't succeed on self-defense. And like you said, you risked using that affirmative defense and therefore admitting that you meet the elements of the crime. She's convicted of murder, has life, as does somebody else who committed more, I guess, quote unquote, true malice murder.
And there's a trial penalty. If you decide to go to trial rather than taking a plea, you are going to see a harsher sentence. So even if you have a viable self-defense claim, there's a real disincentive to trying to put it forward, because if you try and you fail, you are undoubtedly going to hit that harsher sentence.
Mm. And it's really challenging for survivors, to your point. And I think there's a lot of, they end up pleading to non-negligible sentences because the system so many times has said, I don't believe you, whether it's police or when they were indicted for this to begin with and have gotten to this point, or just in kind of experiences out in the world, and the impact that our kind of sociocultural views and the way we handle abuse as a society tend to play into these things too. I think another to that point, and then I'd love to talk to you more kind of about the consequences of this problem on other folks in the community. But I think to that point, and now I'm forgetting what I was going to ask you. It came to me, now it's gone. So now we're paused. I was going to ask you about, oh, in kind of thinking about, as you put it, really just explaining why these things happened. Something we see, or at least I see a lot in my practice, is facts that are really spun as really bad facts and kind of, we think self-defense, we predict it would look a certain way. If you didn't have a super thorough understanding of trauma or personal experience, you might expect that a situation where self-defense with a survivor protecting herself from their abusive partner might look like he was holding a gun to her head. They wrestled, she got the gun, she shot him, and then she immediately calls 911 and says, I was scared. I had to protect myself. Please come send help. I don't want him to die. Something like that. But that things happen like folks say, no one's going to ever believe me and try to cover it up. Or she's not responding to the police in a way that they would expect, kind of to what you talked about earlier, meek and scared. And so kind of these facts but we know that flat affect is, for example, a normal response to trauma, and that might be spun against her. Or we know trauma affects memory. And so they might say, you've changed your story. So what are some of kind of those maybe examples that you see and ways that you think the system kind of mishandles these aspects of these cases?
It's exactly what you've just said. The idea that I've killed somebody, I don't know what to do, and I'm going to put it away for a minute until I figure out what to do, or I'm panicking and I'm trying to figure out kind of how can I keep this from destroying my children, destroying my family, um, dealing with guilt, dealing with trauma, leads people to do things that don't look entirely victimy. And so people, I'm thinking about, for example, the case of Dixie Shanahan, who her husband said to her after 19 years of abuse, some of the worst abuse you can imagine, said to her, "You are not going to make it through that day. I'm going to kill you and I'm going to kill our unborn child." And she genuinely believed that. And they struggled over a gun and she shot him. And then she put him in a back bedroom in their house and just kind of left him there because she didn't know what to do. And she was seriously traumatized. And the way that that read, both in the press and in her trial, was, oh, she was conniving. She came up with this whole big plan, and then she did all these things to lie to people about him, where he had gone. And that's just trauma and not knowing what to do in that moment. Um, and so you see behavior like that all the time. If you can explain it adequately, maybe you will get a finder of fact or a jury to believe you, and maybe not. And in Dixie's case, she ended up convicted of second-degree murder, sentenced to 50 years. That was later knocked down to 35 by the governor of Iowa.
Thank you. Super helpful because it's hard to get to your point. Even after the explanation, we still face the battle of, do people believe it? And how seriously do we take accounts of abuse? And what kind of expectations do we put on survivors? Because it feels like we kind of, in the system, it's like, what alternative did she have apart from risking her own safety and the safety of her children? That it was really, she would have died otherwise. So do you expect her to sit there until the point that she dies and is, to your labeling, the perfect victim in the way that we understand victims to be?
And in that case specifically, they was a small town in Iowa. Everyone in that town knew that she was being abused. Everyone knew what he was doing to her. And she had gone to prosecutors and police 3 times. He had been convicted twice. He spent 2 days in jail the second time and no time in jail the first time. Not that I think that, as I've said, criminalization makes it better, but she knew the system wasn't going to help her. The third time that they went to prosecute him, she left, went to another state, and they brought her back. They made her come back. So if you're looking at the system and thinking, well, this is what the system has done for me, why would you ever think, oh, if I just call the police, it's all going to be okay? She had no reason to believe that. Everyone knew what was happening in that house. No one stepped in a useful way to help her.
And I think that brings up such an important point too of how again, the system fails at every juncture, including way before the survivor is arrested, and the importance of, like you noted earlier, domestic violence prevention work. Because if we were, doing a better job of training and equipping frontline responders and having more adequate resources, that's such a great illustration of what you described earlier, that if we had given her what she needed to leave the relationship before it culminated in such a severe manifestation to where she was put in a position that she felt she really had no choice but to do that to save her own life. Um, so we know that obviously this affects survivors themselves in a really horrible way, and looking at their, the direct consequences of criminalization. And also, I think, the emotional experience of abuse tells you, your abuser often will say, and implicitly or explicitly, that what's happening is your fault, or you could have done something to stop it. And society victim blames. And then we really explicitly blame people by giving them criminal convictions. But we know that there are also some kind of, apart from the conviction itself, there are other direct consequences to criminalization that you talked about this a bit in the beginning, but that make it harder for survivors, even if they do have the opportunity to be released, to reenter into society. And also hard on their families, which we can talk about more explicitly. But would you mind talking a little bit about kind of what you've seen and how this problem manifests for people generally in the criminal legal system, but for survivors specifically?
Yeah, I want to talk about the second thing first, if that's okay. I was talking to a client the other day, and she's my age, about 55, And we were talking about being part of the sandwich generation. And what that has meant for incarcerated women, particularly, is that they are trying to care for both their children and their parents while they are incarcerated. They're the caregivers of the families. And when they are gone, it creates unbelievable stress and tension for the family. And these women are trying to still do that work from from prison. Sometimes their children forgive them and sometimes they don't. Sometimes they are not able to see their children anymore because if they have killed a partner, their partner's family may have taken those children and severed those relationships. Um, Sometimes their children are very angry with them, don't forgive them for the things that they've done. Those relationships can be very difficult. Parents are stressed with children who are incarcerated, trying to support them, but also aging and not having the support that they need as they age. And so you see that stress and that tension and that worry. My client was telling me she um, frequently tries to call her mother's doctors to be able to talk to them about her mother's care, and that's almost impossible to do from prison, but she is the only person who can do that work for her mother. So the burden that is put on families and on caregiving is so huge. Um, but in addition to that, if you are able to be released from prison, and most of my clients are lifers, and so we look at folks who are serving very long sentences, but if they're able to be released, the stigma of having been a criminal defendant and an incarcerated person stays with you. Many of my clients try to change their names so that they can't be followed once they are released from prison. But there are state's attorneys who will oppose name changes for our clients because they believe that they should continue to be associated with their crimes forever. Um, Getting a job is more difficult. Getting housing is more difficult. Making a living is more difficult. Your income is depressed. Getting access to medical care can be difficult. Getting access to trauma-based services can be difficult because if you have been labeled the criminal defendant, then even for many anti-violence professionals, you are not eligible for their services, notwithstanding the fact that you were a survivor before you went in. Everything is harder as a result of criminalization. And that's not even to speak of the trauma that you have experienced while you have been incarcerated. If so, Beth Ritchie has said that she never met a black battered woman who wasn't incarcerated, who wasn't a victim of trauma. I have met no women in my practice who weren't victims of trauma before they went in. But even if you weren't, prison is trauma. Prison is a trauma inflicting institution. Being strip searched is trauma. Being yelled at and belittled and physically and sexually and emotionally abused by correctional officers is trauma. Being isolated is trauma. Being kept in conditions that are not fit for habitation is trauma. I could keep going, but you get what I mean. And so you're coming out with all that trauma and with very few resources to help you address that trauma, while at the same time you are trying to have your basic human needs met, and oftentimes while you're stepping right back into a caregiving relationship. So the children and the parents who've been waiting for you while you were on the inside, they want you now. And trying to work through all of those things at the same time is incredibly difficult.
Super impactful the way you described it, and really I think paints a helpful picture of the way that kind of I feel like a lot of us in society in other ways, and maybe people who work in more of the family law space or children and family services or just out in the world, we see that we place such high expectations in society on women, and women wear so many hats and really bear a heavy load within their families or in their communities, and that expectation is still there for people who are incarcerated, and people put that expectation on themselves, and that mothers who are incarcerated still love their children and want to be parents and supportive as best as they can, despite the obviously enormous barrier of being on the inside. And we know that too, for children, it's difficult for children and it's harmful for children. There's obviously research to back that, being separated from their biological parent, having an incarcerated parent, trauma is generational. So that's, children are already at risk of detrimental outcomes in their future. Would you mind talking a little bit about the effects on children themselves, of having moms in prison?
So there's the obvious stuff. You don't have the person to whom you've been bonded since before you were even out in the world. You don't have that comfort. You don't have that basic care. But beyond that, there are questions about who you live with, and what those people are telling you about that parent and how much of a relationship you can actually maintain with that parent. There are the effects of the trauma that may be visiting out on you if you were exposed to what was happening in your home prior to the crime. So kids who are exposed to intimate partner violence suffer from all kinds of both mental health challenges and physical health challenges. There's just a range of things. And kids are generally pretty resilient, but depending upon the level of exposure to violence, they may have real harms that are associated with that they are then trying to work through. They can be ostracized or isolated from other people because of having an incarcerated parent. I know one of my clients, her children were told that she was away at school because they didn't want to tell the kids that she was in prison. And so the kids couldn't understand why this school wouldn't let their mother come see them. Kids are also angry and resentful of their parents who are incarcerated, and they may act out to show their incarcerated parents that they are angry and resentful. And this stuff doesn't just happen when children are minors. These effects keep going into kids who've reached the age of majority. Just because your child is an adult doesn't mean that they're not mad at you for having missed their childhood. And I hear a lot when we work with families around parole and sentence modification, those can be really conflicted conversations about both how desperately that child wants a relationship with their parent and how angry they still are at that parent for not having found some other way. And particularly in cases where one parent has killed another parent, that can be unbelievably difficult for kids to process. So, some of these kids end up in the family protection system, the family policing system, some of us call it. They end up in terrible foster homes where they're continuing to be exposed to violence. Some of them end up with maternal relatives who may have strong feelings about the choices that their family members made, your clients made. Some of them end up with paternal relatives. That often leads to a destruction of the relationship altogether. But there are very few unequivocally positive outcomes for kids whose parents are incarcerated. And that's not even to speak of the financial instability that comes with having an incarcerated parent and all of the other kind of things that are attendant to it.
Absolutely. And really, again, one of those things that the emotional impact of abuse isn't so cut and dry, and the emotional impact of trauma is really complicated, but that it's hard for kids to really, and to your point, children of incarcerated parents, children being people of all ages who that is their parent, to really understand what happened and why it happened when that situation is obviously as personal as it gets for them and might involve multiple family members or both parents. I've got one more question for you before we kind of wrap up and let you share anything else that you think is important. But in talking about parenting, I think a big challenge facing our criminal legal system and people affected by it in our country is how the criminal legal system and prisons treat people who are pregnant. And obviously there's some tie to, we know that folks who are pregnant and who are being abused are at high risk of lethality. So we also know that, women who are incarcerated, statistics show that 75 to 95% of them identify as having experienced abuse at some point before they went to prison. To your point, in my experience, I've never spoken to a woman in prison who has not experienced abuse or trauma before they came in. But we can assume again that, obviously the phenomenon of pregnant women in prison in and of itself is supremely important. And we can also assume, based on statistics, that a lot of those incarcerated women who are pregnant have experienced abuse. So definitely relevant to the criminalization of survivors. But would love to hear from you just kind of on what you see. We know there are a lot of challenges with children being taken away right after they give birth, or the conditions in which incarcerated women give birth, like being shackled or whatever it might be, not receiving adequate health care, kind of what you've seen with that and what that experience, that horrible experience is like for people who are pregnant and give birth in prison.
So if you've been pregnant, you know about the ways in which you feel sick all the time, maybe early on, and the cravings that you have, and the hunger that you have, and the body aches and body pains that you have, and how hard it is to sleep, and the different things that happen to your body. Imagine doing all of that in a space where you have no freedom to dictate when you do certain things, what kind of foods you eat, what your physical conditions are going to be like on a hard steel bed with not a very good mattress, with inadequate. And when we say medical care in prison is inadequate, that's a kindness, with unbelievably draconian medical care, and with people who look at you as though you are a complete failure as a person and as a woman and as a mother for being pregnant while you are incarcerated. Add to that states where you still can be shackled, both when they take you to prenatal appointments, during labor, and when they take you back, even if you've had a surgical procedure. Now, having given birth twice, I can tell you that I was not running away from anyone during that experience. No one would have needed to shackle me to anything to keep me from doing that. But we still have, in some places in the US, places where people are being shackled even during active labor, which is just, I can't even tell you how disgusting it is. I haven't seen it with a pregnant patient. I have seen it with a patient who was receiving chemotherapy as a result of breast cancer, who was shackled to her bed, even though she was so sick she couldn't stand up. It is the most inhumane thing that you can even imagine. Okay, so all of that happens. And then you give birth. And in some places, the baby is taken away from you immediately. You barely get to hold the baby at all. In some places, you might get a few days. And in some places, there are things like prison nursery programs, which seem like a great idea until you realize that at some point, there is always going to be a separation because nobody is letting kids stay in prison with their mothers as a general rule, particularly with longer sentences, through the duration of a sentence. And so we're breaking that bond at some point always for pregnant people. For pregnant people who don't want to carry to term, the state's abortion laws can have a tremendous impact on whether you get to make what in some places is a legal decision for you to make about terminating a pregnancy, either because the state is not willing to allow you to do that, or because they drag their feet so much that you get to a point in the pregnancy where you can't do that. That's a huge issue as well. And just all kinds of reproductive health are implicated by being in prison. You're not getting adequate reproductive health care. The other piece of this that, again, my friend Quanetta Harris, who's incarcerated in Texas, has talked about a lot is the lack of basic knowledge and information about reproductive health and reproductive health care among a lot of women in prison. She was a nurse before she was incarcerated, and she has a group of kids who are incarcerated with her, and she is the only sex ed they have ever had. And so, these kids are experiencing all the things that we all experience with our bodies, but they don't have any idea what's happening to them. So imagine not having a Quanetta and going through pregnancy and trying to figure out what's going on with your body and not having access to information and not having access to the things that you need to make sure that that baby is safe and thriving. There are so many parts about being pregnant in prison that are absolutely unbelievably inhumane, that it would be hard to get all of them done, even if we had 2 hours to talk about.
Thank you for that. It's so cruel and horrible. And I think too, it's things that, to your point, we take for granted out in the world about just like access to information via the internet or even books. We know that prisons tend to have inadequate information sources, and we, I think, forget the basic access that we have to the doctor or after women give birth, what kind of care they need and complications that might arise, and the way that we can out in the world prepare ourselves and keep children safe, to work towards healthy birth and postnatal care that people just really don't have.
Yeah, I mean, the worst stories we hear are the stories about women who go into labor and nobody believes them and nobody hears them and nobody takes them to get the care that they need. And when you hear those stories, it's easy to think, well, those are outliers and everything else must be okay. Those are outliers and everything else is bad too. And I think it's really important to understand that there is no normal, useful, healthful prenatal care that's being provided to people who are in prison environments.
Hmm. Thank you for that. Super informative and really, really important. Well, before we go, just a last kind of question and to you and kind of a general question is, I guess, what you think, two questions. One, what do you think are some really important and effective changes that could be made in terms of law and policy to better help criminalize survivors? And then kind of just, these could be interrelated. Some of the most important takeaways you hope that if people were to take a couple of things away from listening to this and take out into the world, what you would hope for people to know and understand.
So I'm going to combine those two things together. I have become a prison abolitionist because I believe that it is deeply immoral for people to be caged and that it's not solving any of the problems that we purport to say that it is solving, particularly the problem of violence. But I recognize that it took me 30 years to get there and that people may not be there yet. If you want to help criminalize survivors, there are a bunch of different things that you can do on the way to abolition that would be unbelievably helpful. So things like get rid of mandatory arrest laws. Mandatory arrest laws require police to make an arrest at a case involving domestic violence anytime that they have probable cause to do so. And after mandatory arrest laws came into vogue in the late 70s and early 80s, studies showed that arrest rates of women were sky high. And the reason for that was not because women had all of a sudden become more violent, it was because of the way that those laws were being administered. Mandatory arrest laws hurt women and girls. We should get rid of them. We should get rid of mandatory minimum sentencing. Again, something that came from a good place, the idea that we could get rid of some of the extreme racist disparity in sentencing by creating mandatory minimums, has just turned into draconian sentencing for everyone. People don't need to be sentenced to life. They really don't. People change, they grow, they get elderly, they age out of crime, they are taken out of the situations that led them to be involved in things that are called criminal. And so you know, that I think getting rid of mandatory minimum sentencing is a huge one. Getting rid of cash bail. Cash bail keeps women incarcerated at times that they don't need to be because they don't have the resources to make bail. And it influences them to plead because if you can't make bail and you're going to be stuck in jail or prison, you're going to plead out. And so they plead to things that they shouldn't plead to because they feel like they don't have any other choice. We could get rid of that. We can change the laws that we've talked about around felony murder, around duress. There's self-defense things that we can change that we haven't really talked about, but I know that the Georgia Coalition is doing an amazing job working on in Georgia. There are people working on it elsewhere. We can create mechanisms for people to get back into court after they've been convicted if they were not able to raise evidence of domestic violence in their original trials. So in New York, that the law is called the Domestic Violence Survivors Justice Act. It's being used to allow people whose crimes were substantially related to the perpetration of intimate partner violence to come back into prison and argue for come back into court. I'm sorry, not prison, and argue for shorter sentences. We should be passing laws like that. And we should be doing that for all victims of trauma and not just victims of intimate partner violence. Anybody who's experienced trauma should be able to put that evidence before a court somehow. We can change parole. First of all, there are a lot of states that don't even have it. Half the states don't even have parole anymore. They should. And for those places that do have parole, we can find ways to build information about the experience of being a survivor into the parole system. All of these things are things that we can do outside of the kind of pie in the sky, some say, things that we should be doing to prevent violence in the first instance, making sure that people have safe and affordable housing and food to eat and medical care for physical ailments and mental health ailments and green spaces and all of the things that we know that people need to thrive, because those are all things that will prevent violence from happening in the first instance. So if we could do any or all of that, you don't have to be an abolitionist to want to see that happen.
Thank you so much, Professor Goodmark. And I really, I think a big takeaway I hope people take from this is I really liked your phrasing, things that we call criminal or things that are called criminal, because I think a whole, kind of one of the overarching things that we talked about today and that we talk about in this issue is that we tend to criminalize people and criminalize actions that are really acts of survival, or we criminalize things and people because we don't take into account what we understand or should understand about their situation and about abuse and trauma and whatever it may be. Um, And again, I think reiterating, we're super grateful for like our member programs who do prevention and direct intervention services for DV survivors. So that's something that I think people, even not in the field, can take away and take into the world, that you don't have to be working in the criminal legal system even to affect positive change in this issue by talking about it or by contributing to domestic violence programs in your community or other programs, and like you said, people having their basic needs met that can help on the whole stop this problem and stop the train from ever leaving the station if we can let people live safe and healthy lives from the beginning. But we so appreciate your time and you sharing your amazing expertise with us, and we look forward to continuing the conversation with you in the future.
Well, thank you so much for having me. I have loved partnering with y'all, and I hope that I get to keep doing it.
You definitely will. Thanks so much. Thanks so much for tuning in to Until They're Free. We hope you learned as much as we did from our conversation with Professor Goodmark, and we hope you will visit her website at leegoodmark.com to learn more about her publications, her books, her works, and her amazing experience working with criminalized survivors. Learning more about Professor Goodmark's work is always extremely informative, educational, and also inspiring to get involved in the movement to end the criminalization of survival. Thanks so much for tuning in, and we hope you will join us next time on Until They're Free.